Hi, I'm Renee Osipov with Chelle Law, and we assist nurse practitioners with employment contract issues. Today we're talking about, is a 10-mile restricted area within a non-compete clause reasonable for a nurse practitioner? So before I kind of address that question, we kind of need to go back and go over what is a non-compete clause. Normally, a non-compete clause is made up of two parts. So the first part is a restriction of time. So after your employment is terminated, you're normally restricted from competing with your employer from anywhere between 1 to 3 years. I always try to, advise clients that 1 year is probably the lowest that they'll go. Occasionally I've seen 6 months, but 1 year definitely you should push for when speaking and negotiating your employment contract. So we have the restricted period of time. So you cannot compete with your employer for a certain period of time, 1 to 3 years. Then the second part of that is a restricted area. It's normally a radius of miles. So that can be, it can really vary depending on where you live. It can be 1 mile. We're talking about, 10 miles today. Is that reasonable? And how is that calculated? So normally the court refers to the phrase as the crow flies, which means they literally put a dot on the map, draw a circle around that, and that's your restricted area. Number one misconception with non-compete clauses is this is not miles on a road. This is miles on a radius that you can put a dot down from the location that it attaches to and draw a line around there. And that's what you're restricted from. So now we're up to the how many miles is reasonable. And we get the question a lot, is 10 miles reasonable? And it really just depends on where you are located. If you're in a rural area, 10 miles might be reasonable. If you're in New York City, absolutely not. But if you're in a city like Phoenix, 10 miles might not be unreasonable because our city is so spread out. You could just go to the other side of one of the suburbs. You could commute easily and find work. So 10 miles may be reasonable. It really just kind of depends on where you are in the United States. The other thing you want to consider when you're looking at this 10 miles restricted area is how many locations does this restriction attach to? So if it's only your primary location, so you're only restricted from that 10 miles, the court may find that reasonable, again, depending on where you live. But if you sign an employment agreement that states that multiple locations will attach that 10 miles, meaning sometimes the language says if you provide services at any location, then the non-compete clause attaches to that. So let's say you've covered for someone while they're on vacation. So then that 10 miles would then attach to that location. So let's just say we have 3 locations out there and 10 miles is going to attach to all 3 of those locations. You're looking for upwards of 30 miles that you're restricted from working. Now, that's definitely going to be unreasonable. I've actually seen contracts where it states any location of the practice, whether you've been there or not, you're still restricted from providing services. And that's even more difficult because, especially if it's a large practice, it's going to be a huge area. So 10 miles could be unreasonable, but again, it really depends on where you are in the United States and then also how many locations is that 10 miles attaching to. A non-compete clause is kind of tricky. So this is something specifically I always feel like it's best to speak with an attorney about because they can kind of pick it apart and make sure that it's reasonable for you so that if your employment agreement ever is to terminate by you or your employer, you're not in a really difficult decision or position after you're able to find work without having to up and move yourself, sometimes even out of the state. So if you'd like more information, you can check out our website at Chelle Law, CHELLE law.com. We have lots of content on there and our contact information if you ever want to consult one of our attorneys on an employment contract issue, such as this with a non-compete clause. Thanks.